I won't necessarily belabor his full and impressive resume. It's a compromise, though. But I will say that Steve Wright is the president and senior counsel of the Southern Center for Human Rights in Atlanta, Georgia. And he's been at the Southern Center for more than 3 decades now, but has also tried cases and argued cases before state and federal appellate courts for many places in his career. He's thrice argued and twice won cases before the U.S. Supreme Court in cases involving racial discrimination in the composition of juries, which you heard him talk a little bit about earlier today. But most recently, he argued in Foster v. Chapman, which we expect a decision relatively soon, fingers crossed, Snyder versus Louisiana in 2008, and Amadeo v. Zant in 1988. So yeah, this could be a 3-for-3 record coming up relatively soon if Foster goes well, and we hope and think it will. And because he doesn't have enough to do, zealously representing death row inmates and other prisoners in Georgia and Alabama, mentoring young lawyers and law students, speaking across the country about a variety of issues related to indigent defense, sentencing, judicial independence, and prison conditions, he also decides he needs to add to that plate and teaches at Yale Law School, where he's taught since 1993. He's been teaching at Yale exclusively for several years now, but he also has taught at several other law schools, including Harvard, Georgetown, go Hoyas, Emory, Georgia, and Tennessee. So I would be remiss not to note among Steve's many national awards, I've heard he's most proud of being awarded the Angry Man of Indigent Defense Award. But he's surely at least second most proud to have received the ABA's Section of Civil Rights and Social Justice Thurgood Marshall Award back in 1998. And while all of these experiences and accolades are really true and important to recognize about Steve, those of us that have been around him know that what makes him truly special is totally unrelated just to credentials, but it's that unique combination of kindness, gentleness, and blazing fire that comes through simultaneously somehow, unique to any other person I've ever seen. And whenever that's true, whenever he talks about his clients or injustice, or as I've learned, maybe it's debating the best characters or best shows of Broadway musicals in the 20th century, because guess what, guys? Apparently Steve's into Broadway musicals. It's this unique mix of fire and friendliness, I think, that makes him an inspirational figure in this movement and a particularly effective advocate. But I will say that Steve doesn't also do all of this alone. He's truly part of an amazing team at the Southern Center who all radiate similar passion and polish and help make Steve great just as he helps make them great. So I had an honor of spending a summer at the Southern Center when I was in law school, and it was a profound experience for me. And certainly it's part of why I still do this work. It was a fun time working with great folks and learning from Steve, but it was also a heartbreaking summer. The summer I was there was when the center's longtime client, Daryl Grayson, was executed that summer. And he was executed after a denial by courts and the governor to test DNA evidence that had never been tested. And sadly, I had to kind of remember about what the legal issues were at the time, because that's not what stuck with me. It wasn't the legal claims, but it was rather how Steve talked about the man he knew that left me, and I remembered in thinking about Mr. Grayson, who had become a friend to many at the center and Steve over the years. And in fact, I kept the email that Steve wrote to staff on the day before Mr. Grayson's execution, telling us all about who he was as a person and how he tried to contribute to society as a prisoner. And I know Steve's not planning to talk about this case, probably, or his approach to client relationships tonight. We're going to talk about the indigent defense crisis, but I will say that the loving and gracious way he talks about his work with these clients is what has always touched me most. And so, of Mr. Grayson, for example, he told us all, his life in our association with him reminds us of how fortunate we are to have the privilege of working together for Daryl and people like him. I am, and I always know Daryl has been, grateful to everyone here for all that he's done, all that we have done on his behalf in all regards, and for all of our willingness to help in any way possible to prevent his execution. So, sadly, not all capital defense lawyers are like Steve Wright. And so tonight he's going to talk to us about the impacts of what happens to justice and lives when death penalty attorneys are underfunded and underqualified and not. Please come talk to us.
very much. We went from one emotional plane to another there. I want to congratulate you. You're almost home free here in putting this on. So all for. And I saw Alex Kosinski walk out when I started to speak, but he came back in. So thank you for doing that. You guys are real gluttons for punishment. Mark Twain once said it's an awful death to be talked to death. And we've had a lot of talking in the last couple of days, and you're nice to sit and listen to a few things that I have to say. I've been more than a little upset about the right to counsel and our failure to make good on the promise of the Constitution. People often talk about the promise of Gideon versus Wainwright, but it wasn't a promise, it's a constitutional ruling of the Supreme Court of the United States. And it's a disgrace to our legal system. Supposedly a system based on law, that we have done such a poor job all over this country, everywhere, not just in Texas, in providing people with representation. It was interesting, just this week the Supreme Court decided a case, Lewis versus United States, in which they said you could keep your forfeiture money in order to hire a lawyer. And I thought it was an interesting, one of the reasons they gave was the fact that if you couldn't retain your own lawyer, the chances that you'd get very good representation from a court-appointed lawyer were not good. And it's a sad commentary that would be a justification. They did the right thing in the case. But basically, you know, since Gideon has been decided, there have been, you know, tremendous limits on resources. There's never any shortage of money to prosecute a case, but there are tremendous limitations on what there can be to defend a case. Even whether the lawyers who do it can be paid a living wage to do it, or even the minimum wage in some places. Of course, the riddle that we've never gotten past is that how do you get governments that are in the business of arresting, convicting, fining, imprisoning, executing people to pay for the cost of frustrating those very goals. And the fact of the matter is we have largely failed with regard to that. We can process people more quickly if we don't give them very good lawyers. The prosecution can almost always win its case if it's representing a client against a public defender with a caseload of 500, or a court-appointed lawyer who's drunk or under the influence of drugs or suffering from Alzheimer's or the other issues that we see from time to time. And of course, many of these programs that have been set up are not independent, which I'll come back to in a moment, but they're really just to run people through the system. And in the short run, that saves a lot of time. If you go to the courts that I go to, where people meet a lawyer, plead guilty, get sentenced, and all that happens within a 10 to 15 minute period, and that's all the lawyering, that's all the judging, that's all the legal process they're going to get. It saves a lot of time, but the enormous price of that is the legitimacy and the credibility of the system. And the inability of the system. I always say, I don't know how many law students are left, but I always say there are no small cases. If you're arrested and you're put in jail, what do you want? Those of you who've been in jail, anybody want Jimmy, you know what you want. You want out. And you want a lawyer to get you out. And there's no such thing as a small case, because the person who means will have a lawyer there to get them out, and they'll be out that day, and a person who doesn't, Diego Moran, facing the death penalty, in Del Rio, Texas, asks for a lawyer, waits 8 months before he ever sees a lawyer. Doesn't have anybody come talk to him, to tell him about the charges, to find out what's going on, to see what kind of investigation ought to be launched. And when you can put somebody like that off for that long a period of time, you've just got a rigged system. I mean, that's all there is to it. Texas has released, of course, and the ultimate price is the 13 people that have been released from death row, including Anthony Graves, who'll be here tomorrow. And oh, Anthony Graves! It's always good to have a little democracy. demonstrative evidence. And I should also, where's John Thompson? He's here too. Who, of course, spent so many years on death row in Louisiana before he was exonerated, and then won a huge judgment, which was taken away from him. But is a good friend, and I'm so glad to know him. And I'm so glad to see Anthony here today. I had Anthony right after he was released come up to speak at Yale, and I told him after it was over, I said, "You are the Stephen A. Douglas of our era." I tell you, what a speaker, and what a great night that was. But it's impossible to know about a lot of other people, like Judge Kaczynski talked about Todd Willingham, whether it was arson, whether it was accidental. Carlos de Luna, who probably was not the person who was convicted of a crime committed by a fellow named Carlos Hernandez. And there are lots of others. You can decide for yourself. You can read David Gann's piece in the New Yorker about Willingham. You can read Jim Liebman's book, The Wrong Carlos, and see where you come out after that's over. But no objective person would say that the trials that they had were in any way fair, or that the lawyers knew what they were doing, or that they had resources for experts and so forth. Ernest Ray Willis, convicted in 1987, same type of arson, almost on all fours with the Willingham case. The only difference is he was represented by the New York law firm of Latham and Watkins. And they spent whatever it took to get the best arson investigators and the best people they needed, forensic people they needed in, and by the time they got through with it, they went to the prosecutor and they dismissed the case because Ernest Ray Willis wasn't guilty of anything. And what this is not an example of the system working. This is an example of winning the lottery. Switch the lawyers, and you switch the outcome. If Todd Willingham had had the services of Latham and Watkins, he would almost undoubtedly be out. And if Ernest Willis had had a court-appointed lawyer, he would almost certainly be dead. As Judge Alcala said just a moment ago, we see bad lawyers at every stage, at the trial stage, at the appellate stage, the post-conviction stage, and as we go into federal court. And I want to say one thing about Anthony Graves and about his case, because there's a decision in the reporters, the Texas Court of Criminal Appeals, that I have my students read. In fact, I just had them read a couple of weeks ago, and they think it's a parody. They think really that I wrote it as a parody. But it's actually an opinion of the Texas Court of Criminal Appeals. And I should say this for everything I'm going to say tonight. I am not making this up. Anthony Graves was appointed a lawyer 2 years out of law school, knew absolutely nothing about habeas, nothing about post-conviction, nothing about what to put in the petition, nothing about nothing. This lawyer was shouldn't have been allowed to practice law, and he sure shouldn't have been allowed to be Anthony Graves' lawyer. It's an innocent man going into the state post-conviction process, and he gets a lawyer who doesn't know anything, and the court rules that although the Texas statute says you've got a right to a competent lawyer in habeas, he's only competent when he's appointed. He doesn't have to be competent after the appointment. Only a lawyer could come up with that, right? Of course, you can put to one side the fact that the fellow who was appointed wasn't competent even when he was appointed. Nonetheless, that case is cited, and of course, if things had not, if it hadn't been for the Innocence Network and other people who come in, these so-called interlopers, you wouldn't be here with us tonight. And so we're very grateful that that happens. This is the 40th anniversary of Gregg, and Gregg, the Supreme Court said, where there's a life at stake, the court must be particularly sensitive to ensure that every safeguard is observed. As we heard yesterday, and as we heard again today, procedural default, procedural default, procedural default. We keep having all these cases decided in the Texas Court of Criminal Appeals and wherever by procedural default. Providing competent lawyers means there are no procedural defaults. The lawyers know what the procedures are. They comply with the procedures. They appeal the cases. They comply with the appellate procedures. And there are no procedural defaults. The court also said that accurate sentencing information is critical, indispensable, in fact, if this death penalty system was going to work. Of course, that depends completely on the lawyer. Who's going to do the investigation into the life and background of the person? And there are too many to name, but we've seen one spectacle after another over the years here that you would just think as a lawyer, that we as a profession, that people going into the profession would just be deeply ashamed of. Robert Holsley, executed last year in Georgia. His trial lawyer, Andy Prince, Andy drank a quart of vodka every day during the trial. Now, you may not have a good sense of how much that is, but that's 21 shots of vodka every day. 21 shots of vodka. He was not that upset about the case that he was trying, the death penalty case that he was trying. He was upset about the fact that he was about to be indicted and disbarred for stealing client funds. But he wasn't really focused on the case of Robert Holsley. He failed to put on, and this is the mitigation part, he failed to put on evidence that Mr. Holsley was intellectually limited, and that is that he had grown up in a house and was subject to abuse, as Judge Rosemary Marquette said, so severe, so frequent, and so notorious that his neighbors called his childhood home the torture chamber. The jury never heard that. Never heard anything really about Robert Holsley, but he got executed. I've seen case after case, three, I've handled some of them, where lawyers referred to their clients with racial slurs. Of course, in Houston, the capital of capital punishment, we've had 3 cases in which lawyers slept during the death penalty trial. Judge Andre Davis and I were talking about the 4th Circuit just handed down their first sleeping lawyer case, and they borrowed from the 5th Circuit sleeping lawyer cases. As we were saying, you're really scraping bottom when you're talking about whether a lawyer's sleeping during a death penalty trial. I mean, the en banc 5th Circuit struggled with this. How do we know he slept through any important part of the trial? Well, we don't, because he was asleep. Sort of a catch-22. Every now and then he did say something stress, but he did not let us know when he came out of it. And that was Joe Frank Cannon, in that case, who slept in a lot of trials, and yet the judges in Houston appointed him to case after case after case, including the 7 people he put on death row, Ron Mock, the 14 people he put on death row. We got people in Houston that have had more clients sentenced to death than the death rows of many states in this union. As we heard, half of the capital cases in the Texas Court of Criminal Appeals, the lawyer doesn't show up for oral argument. Where I come from, if you don't show up for oral argument, you're held in contempt of court. And the oral argument is rescheduled, and you better be there or you'll be brought in chains. The same thing for the habeas cases. We know intellectually disabled people are being executed despite the fact that they're not even eligible for the execution under the Atkins case because the lawyer didn't understand what intellectual disability was and didn't put on any evidence of it and missed it completely. And of course, with so many, and there are some exceptions, but so many cases, and we heard about it from a judge of the Court of Criminal Appeals today, about how bad the lawyers were, as I believe she said, at every stage. That there was procedural default after procedural default. She was talking yesterday, and she and I had a little chat afterwards about this fact that 25 years ago, how bad all the lawyers were, when Cannon and those people were representing people. But I think that right there, you have what the problem is. 126 people have been executed from Harris County. That's more than any state except Texas itself. It's more than Oklahoma, which has had 112, more than Virginia, which has had 111. No other state is over 100 executions besides those states. How does one county carry out 126 executions in this 40-year period? And it's the Texas not-so-secret. Aggressive prosecutors, Johnny Holmes, seeking the death penalty in every opportunity, and then his follower, Chuck Rosenthal, until some emails came out that caused him to retire a little early, but aggressively seeking the death penalty at every opportunity, and then appointing lawyers that can't even stay awake, lawyers who don't know any law, lawyers who don't preserve anything. Let me tell you, you give somebody a lawyer like that a trial, you know what I'm talking about now?
Yeah.
And then you give them an equally bad lawyer for the post-conviction process?
I know.
Or even a worse lawyer for the post-conviction process. You can kill 550 people like Texas has done. And you can kill 126 executions. This is a system, and particularly in Harris County, that's got no integrity to it whatsoever. And the sadness of the willingness of the courts to tolerate it, there's a lot of talk about all the reasons. We don't have enough resources. We don't have structure. We don't have independence. We have a lot of reasons, but one that's not talked about very often is the role of the judiciary in the poor quality of legal representation that people have. And it's very much a part of it. And, you know, it's a strategy in the law today to try to keep the other side from having a good lawyer so you can beat them. I mean, I think it's dubious ethics, but it's certainly not a fair system. But that is the system. But there's something particularly bad about the judges keeping people from having a good lawyer so the prosecution can win its case and get the death penalty and kill a person. Doug Schaefer was presiding at one of the judges in Houston, one of the trials where the lawyer was sleeping so much that he was snoring. And it was kind of bothering people. And at any rate, they called a recess. And he asked the judge, Judge, how can you preside at a death penalty case? This man's life is at stake, but the lawyer is sleeping. Judge Schaefer said, well, the death penalty, the Constitution guarantees you a lawyer, but it doesn't guarantee the lawyer has to be awake. That's a strict constructionalist if ever there was one. But what is more troubling to me is the fact that these lawyers, no matter how bad they screw up, get appointed over and over and over again when everybody at the courthouse knows how bad they are. Everybody at the courthouse knows you wouldn't have this lawyer represent a member of your family in a traffic case. And we're appointing him to death penalty cases. Let me just mention a couple of cases that I think say something about that. Toby Wilkinson is a lawyer here in Texas. He represented a death sentence man named Justin Chaz Fuller. And he was doing a habeas corpus petition for him in the state courts. But he apparently couldn't really get inspiration, or maybe he didn't read the record, or for whatever reason, instead of filing a petition about Fuller, he just took the brief he had filed 2 years earlier in another death penalty case, Henry Dunn, and he just filed that as Fuller's brief, and complained about testing on the gun and the blood on the gun used by Dunn's co-defendant. Well, Dunn's case was over. Dunn was already on his way to the death house. He'd already screwed his case up. And so here you have a court, and then 3 years later, the same lawyer, believe it or not, has a petition to file for a fellow named Daniel Acker, and he takes the brief he filed in Fuller's case, which of course was the brief he filed in Dunn's case, and he files that in Acker's case. Now, just think about that. If you're a law student, you don't have to write your third-year paper, so you just go back to English class, and when you're a senior, and you just file that instead. How do you think you're going to do on that? How do you think you're going to get graded? I mean, as a lawyer, I mean, what should a court do about something like that? The same thing happened in another case. There's a guy named Leslie Ribnick who was represented a client, and he apparently couldn't come up with anything, so he took his earlier brief in a case Robert Gene Will filed a year and a half later, and he just put it in there, never mentions either client. And those cases go on. So I'm going to tell you, you may have to worry about it as a student, but when you get admitted to the bar, you don't have to worry about it as a lawyer. I mean, these two cases show this. And how would you analyze this? I mean, you get a brief that has nothing to do with the person whose appeal is before you, your appellate judge, and you have a brief that has nothing to do with the client who's before you, whose life is in your hands. Well, one thing might be, fire the lawyer. What about that? Secondly, strike the brief. It's not about his case. Why would we keep it? Thirdly, maybe call Vincent and Elkins or somebody and say, we need a real lawyer here. We've got a man whose life is at stake. And we've got a piece of garbage over here. We need somebody to read the record and to write a brief so that we, the Texas Court of Criminal Appeals, can do our job as lawyers. Well, if you're in law school, that's the sort of make-believe world of justice that we're teaching you about. Those of you who are lawyers know good and well that their phone call went out to Vincent and Elkins. I guarantee you that, from either the Texas Court of Criminal Appeals or the Fifth Circuit. And Fuller was executed, and so was Dunn, and so was the other client. Sharon Keller was quoted as saying that, boy, if we thought somebody was on this list that wasn't doing a good job and ought to be taken off, well, we just take their name right off that list. Well, Toby Wilkinson is still listed in the First Administrative Judicial Region's list for appointment of first chair, second chair, appellate counsel in capital cases. And he's not just listed as somebody you can appoint, he is being appointed. He just got another person sent to death, Micah Brown, in 2013. So this is not a thing of the past. These lawyers didn't go away. Lisa Olson published in the Houston Chronicle a while back 9 lawyers who had missed the statute of limitation for filing a federal habeas corpus petition. That meant these 9 people had absolutely no federal review of their case whatsoever, no review by life tenure federal judges. We heard today a lot about elected judges and what elected judges can do. Federal judges are greatly restricted by statute, but at least they do have life tenure. These lawyers missed any review of their case whatsoever. And there's been another one since, and there may be others I don't know about, but I know there have been 10. One of them was a fellow named Jerome Godnich, who's missed at least twice. He actually missed it 3 times, but the 3rd time the judge didn't appoint him until after the statute had run. So I don't know that ought to be held against him, since it was really the judge who missed the statute of limitation and not Mr. Godnich. But my question about Mr. Godnich is this: why wasn't he suspended from practice the first time that happened? I mean, you can quibble about a lot of things about the performance of a lawyer and how good a lawyer is and how well a lawyer represents a client. But if you can't file your papers on time, I don't care if it's in an automobile negligence case or a death penalty case, if you can't file the papers on time, you are too incompetent to be trusted with any legal matter. And the bar has a duty to protect the public from these people. Well, he missed the next one. I said, well, why wasn't he suspended and disbarred? I actually was in Dallas at the time, and the president of Texas Bar was there. So I asked him, I said, why hasn't this guy been disbarred? I don't understand it. He should be disbarred. He should not be allowed to represent clients. And he said, well, nobody complained about it. I said, complained about it? It was on the front page of the Houston Chronicle. Lisa Olson wrote a whole bunch of articles about it. And the Houston Chronicle wrote an editorial about it, saying this is terrible that we have lawyers that are this bad. Well, what's happened to Jerome Godnich? How badly has he been disciplined? Last year, he was appointed. I mean, you'd think at the very least the judges would take him off the list of people who could be appointed. And at the very, very least, take him off the list of people who could be appointed to capital cases. Right now, he's got 478 felony cases. That's how many people? 2 capital murder cases and 4 felony appeals. And that's in Harris and Montgomery County. There may be others elsewhere. We looked at a lot of his briefs. Well, what there is to look at. Almost all of his appellate briefs are Anders briefs, where he says, I can't see any issue in this case, so I'm just minis in the paper. Yeah, that was my reaction. You know, the ABA guidelines suggest that a full-time public defender handle 150 felony cases. Some people think that's too high. Here's somebody that handled well over twice that many cases in a year's time. This was the number of cases he had in the last fiscal year, for which the Texas Indigent Defense Commission files a report. And he too is still representing people in death penalty cases. His client, Juan Valdares, was sentenced to death in March of 2014. This man is still on the list. And nothing is being done about it. Lisa Olson asked the Chief Judge Hayden Head in Corpus Christi, what about these lawyers missing the statute of limitations? He said, oh, I didn't know anybody was missing the statute of limitations. He doesn't know. He's supposed to be in charge of this system. I mean, that's the big fight. Are the judges going to run the system, or are we going to have capital habeas corpus units, or somebody like that who might know what they're doing? But the judge doesn't know. So you don't know whether, when you're appointing Mr. Diamond to a case, this is his fourth shot at missing the statute of limitations or not. Around the country, there are these capital habeas corpus units in federal defender offices that are people, as we know, that specialize in this. The 11th Circuit noticed that a lot of lawyers in Florida were missing the statute of limitations, but they weren't missing them in Georgia and Alabama, the other two states in the circuit. And they thought that maybe the reason had something to do with the fact that there were capital habeas units in Alabama and Georgia that were monitoring the cases and keeping track of them and making sure that people file within the statute of limitations. It's not that difficult to do it. And it was amazingly how quick it was established. It's already up and running down in Florida right now. Be a good place to apply for summer internship or job. But there is not a single capital habeas unit in the Fifth Circuit, in any district in the Fifth Circuit, and that's preventing people from getting competent counsel. Edith Jones wrote a memorandum to all the judges in the country to share her wisdom about appointing lawyers. The Fifth Circuit is notorious for denying people funds, for cutting lawyers' compensation, and for doing just about everything else to make life miserable for somebody representing a death sentence person here. She recommended that the other courts not allow capital habeas units from other circuits to come in. And she asked the question, why would a lawyer from a capital habeas unit in California come to Texas when we have lawyers from Texas? Well, let's think about that, Chris. One, that capital habeas unit lawyer will probably file within the statute of limitations. That's a good reason right there. I mean, let's get a lawyer in who can compute the time. It's 1 year. It's not that complicated. And let's file within the statute of limitations. Secondly, the lawyer might know something about post-conviction representation of death sentence people. That's not true of a lot of people, Texas lawyers, who are representing people. And also, from everything I can tell, lawyers from capital habeas units do not sleep during their trials, during their hearings. They don't waive appeals. If there's an appellate court that is considering their case, they're going to be there at that podium and argue their case for as long as that court will let them argue. The idea that somebody wouldn't show up. But there's so many misadventures with Edith Jones. I won't go into any, except that one time she did cut off an accounting firm cut off their funding without giving them notice, an opportunity to be heard. And you know, the accounting firms, they're not a lot of lawyers. They say, you know, we don't get paid, we don't work. You know? So they quit working. Without any notice, opportunity to be heard, she filed an order and said, you're going to work for free, and you're going to testify at trial. And believe it or not, she got away with it. They filed in the court of claims and lost. People filed in the case. I just read a very revealing memo that was written by her kind of right-hand man on this, a guy named Joseph St. Amant, just in February. It was written to Judge Maria Cohen of the Fifth Circuit. about providing counsel. This is a person in charge now of coordinating, providing counsel in the court. In my opinion, I'm quoting now, in my opinion, the idea that defense resources should be equivalent to the prosecution is mistaken. They have a very different role. Defense counsel is there to make sure that the prosecution has not made a mistake, and that its case is sufficient, and that it is played by the rules. And if these conditions are satisfied, to help the defendant obtain, the lawyer's job is to help the defendant obtain the best possible outcome under the circumstances. That's all. On the other hand, he says the prosecution has the burden of proof. The trial is a test of the prosecution's case. It's not a factual inquiry into who committed the crime. Boy, I did not know that. It's the government's responsibility to identify and arrest the perpetrator, marshal the proof, and organize the case. The defense is just a quality control check on the process. The disparity of resources shouldn't bother anybody. I mean, this person doesn't even have the most elementary understanding of the adversary system. Doesn't have even the most elementary understanding of the role of defense counsel in a case. I mean, he needs to talk to that team that proved that Anthony Graves was innocent to find out how much time it took to check the prosecution's case. The burden to prove guilt is a significant one at trial. But I will tell you, the burden to prove innocence after trial is an almost impossible one, no matter how strong the evidence. It takes years of work, investigation, and resources. He needs to spend time, you know, I was just trying to lawyer the other day, post-conviction relief, a man is killed, and he's killed for what seemed like a terrible case, the murder of an older man. He was 18, the man was about 54. And of course he got the death penalty. But the post-conviction lawyers found out this man actually had raped this young man when he was 8 years old. And he had sexually abused him ever since for 10 years, from age 8 until age 18. He had sexually abused this kid. And he had also passed him around with a bunch of other people who also sexually abused this little boy while he was growing up. And none of this was presented to you. You get a different picture of the case, don't you? If you know one aspect of it and not the other. And you don't find things like that out without spending a lot of time, without talking to a lot of people. Nobody wants to talk about this stuff. And yet this is the kind of thing we find all the time. And it's done over months and years of investigating. This guy might want to read this Mr. Saint, whatever his name is, might want to read the American Bar Association standards on putting on a mitigation case. Judge Jones has an obsession with saving money. She wrote in her memo, the Criminal Justice Act is not intended to fully remunerate counsel for their services. It's in death penalty cases. That's why we thank counsel at oral argument. For what? Missing the statute of limitations? Thank you, counsel. We have nothing to do. You filed after the statute right now. Or relieving the court of all responsibility to deal with issues. I tell you, you don't get good lawyers by underpaying them and thanking them. When Bank of America needs a lawyer, they don't say, now if you'll take our case, Jamie Dimon will thank you from the bottom of his heart as soon as the case is over. Have you ever known that to work? It just works with poor people. Worst of all, the worst thing I've ever seen here were these lawyers in Raphael Holliday's case who turned on him at the end. First of all, they wrote him a letter to say, you're already through the system. They certainly denied they hadn't gone for clemency. What lawyer would not go see their client when they lost at the last stage? I mean, I get a note from the Supreme Court of the United States that says my client's lost. I'm going to be at that prison as soon as that warden's going to let me in, whether it's that afternoon or the next morning. And I'm going to spend as much time over the next day or two as I can to counsel that person and help that person deal with the fact that now we're facing execution and the possibilities are getting extremely slim. But we're going to do everything we can within the slim possibilities we have going forward. These guys just wrote a letter, and they said, and by the way, we're out of here. We're not representing you anymore. And it's the darndest thing. A legal writing professor at Texas files a motion and says, this guy needs a lawyer. I mean, these people have abandoned him. He's facing execution. He needs a lawyer. The bottom line is, he's denied, the district court denies it. You would sort of think the district court, here's some lawyers willing to, come in on this case. The Fifth Circuit not only denies it, but they put a footnote in their opinion that basically tells this legal writing instructor, you better back off this case. Now, we know that wasn't the right decision because not long after that, or maybe right before, the Eighth Circuit had just denied two lawyers who knew what they were doing coming into a case where the client had been abandoned. And it's quite remarkable. These people knew what they were doing. They came in, they said, we're going to represent him. They didn't say, well, find a lawyer. We're going to represent him. The district judge says, no, you're from out of state. That's no problem. We'll pay. We'll pay. We'll go for free. We'll represent him for free. The district judge still says, no, you're not going to represent him. I mean, that district court was right in there. That district judge was right in there with the Attorney General office of Missouri to try to get this guy killed. But fortunately, the Supreme Court of the United States granted certiorari and held that he was entitled to a lawyer in that case. If I can take just a minute, because this is worth describing to people who've never heard of it, particularly those of you from outside of Texas. The only courts that I know of that have this rule are the Texas Court of Criminal Appeals and the Fifth Circuit. That you must, if you have an execution date, you must file any pleadings 7 days before the execution date. The 11th Circuit, you come up there the day before and you say this guy for some reason shouldn't be executed. Those judges are going to hear what you have to say, but not in these two courts. And let me just give you an example of a case of the fellow Frank Garcia. He was intellectually disabled. He had an IQ of 55. He had a lawyer represent him at trial, didn't put on any evidence about him, didn't put on any evidence about his intellectual disability. And when the case was in post-conviction, the lawyer testified under oath that he had consulted with a psychologist, but the psychologist told him that he had a normal IQ and that he was not mentally retarded, intellectually disabled. So he loses. He was also given some money, but the post-conviction lawyer then is given some money but does not use it. So it goes into federal habeas. Now we get a brand new lawyer in the case, and fortunately, somebody thinks you ought to call somebody or do something. He goes to the psychologist. And the psychologist said, I never did any intellectual testing on that guy. I never tested his IQ. I never said he wasn't. In fact, they tested him, and his IQ was 55. So what do we have on our hands here? We have a guy who's categorically, constitutionally not eligible for the death penalty, but this lawyer had misrepresented what happened at trial, and here we are now, at the last minute, as we say. Jim Marcus is here, Big Bird. They find out about this, they put this evidence together, they go before the Texas Court of Criminal Appeals, but they don't get in 7 days ahead of time. And so they're show cause why they shouldn't be held in contempt. Now, this is the pop quiz. Who of these lawyers should be held in contempt? The trial lawyer who perjured himself by saying he hired a psychologist and got tested when he didn't do it. It was an absolute lie. It was under oath. It was perjury. That's one possibility. Secondly, the habeas lawyer who got $5,000 and could have had a psychological test done, but he didn't. He kept the money himself. Or third, the lawyers who, upon finding that this man was not eligible for the death penalty, rushed into court and tried to say there's a huge miscarriage of justice about to happen in this case. Well, if you guessed 3, you'd be right. Those are the only lawyers sanctioned. And the one that takes them all of course, is David Dow, who's handled hundreds of cases, gotten innocent people out, saved the lives of people because they're intellectually disabled or because of constitutional errors, whatever. They have this rule in the Texas Court of Criminal Appeals, and the rule says 7 days, but then they have an example beside it, which is 8 days, which just proves the Court of Criminal Appeals can't compute the time for filing in their own court. But that's okay. We'll chalk one up. So he files. David is a graduate of Yale Law School. He's been with the Texas Innocent Network. He's been a professor at the University of Houston, 25 years. His pleadings and articles, I would say, are vastly superior to most of those that are being filed by other lawyers in these cases, the people we've heard about, and for that matter, vastly superior to the opinions of the Texas Court of Criminal Appeals. But we won't go there. He's suspended for 1 year. We don't suspend Jerome Godnich for missing the statute of limitations and denying the client all review. But we don't, all these other people I've talked about, Toby Wilkinson and all that. But the Texas Court of Criminal Appeals denies people facing the death penalty the services of one of the most prominent death penalty specialists in the country, in a state that doesn't have enough lawyers, as we heard today. Not enough lawyers. We have too many cases and not enough lawyers. And that's what they did. We know what works. Because if you go to Colorado, you know they have a complex litigation office. There's one of my former students is here from that office. They've had it from the start. And when people are facing the death penalty, they give them representation by people that know what they're doing. Just recently, they had the James Holmes case. That was the Aurora shooting case. Terrible, terrible case. The Dexter Lewis case, stabbing 5 people in Denver. These cases had very complex mental health issues. This was not a matter of checking the prosecution's case, like Mr. Saint, whatever his name is, said. And both those people got life sentences. There are only 3 people on Colorado's death row. I think the difference between how many people Houston has executed and how many people are on Colorado's death row is directly related to the lawyers who are assigned to represent those people in their cases. And there have been others as well, and I won't go into them except to say Virginia and Georgia, we used to sentence people to death right and left, and then both those states, in fact Virginia's executed over 111 people, and then set up capital defender offices 10 years ago. Actually staffed by people that know what they're doing. People who go to training programs on developing mitigation. People who learn how to represent people in death penalty cases. Right now the Virginia death row has 8 people on it. They've only had 2 death sentences in the last 5 years. Last year we didn't have a single person sentenced to death in Georgia. For the year after the office was created, we didn't have a single person sentenced to death. I know that you can't tell completely how good lawyers are by the outcomes of their cases, but I'll tell you, it's a pretty good indication. And if I were picking, I think I'd go with lawyers in Georgia and Virginia and Colorado and a number of other states that have done this instead of the walking violations of the Sixth Amendment that are assigned to people who use it. So the end of this is just simply that it's not impossible, it's not hopeless, it can be done, but it takes the political will to do it, and most importantly, it takes the judiciary stepping up to the plate and doing what it ought to be doing, which is getting out of the business of managing lawyers and having independent organizations, federal public defenders, state public defenders, capital habeas units, representing people. And also for those who aren't saying anything, on the Fifth Circuit, for example, to stand up and say, this is a disgrace. We cannot operate like this. We are a disgrace, and something's got to be done about it. And